Welcome to today's webinar. We are going to get right started because we have a lot of excitement to get through, and we want to be respectful of the So the way this webinar works right now, all participants are on listen only mode, and our presenters have audio and can speak. There are 4 webcams up right now. But after my intro, I'm going to hop off so Priscilla Smith can come on and you can see her beautiful face. And we will do Q&A at the end of the session. I'm going to reserve a good 15-20 minutes for that. If you have questions that you want to ask, we're going to use the chat box because there are 45 of you attending this online webinar, which is super duper amazing. And it's hard to have 45 people talking all at once. So use that chat box if you have questions or comments or feedback as we go along. And I do want to start with thanking all of you for attending. 80 folks signed up for this webinar. The fact that you are joining us today with less than a week's notice when we planned this webinar is really amazing. It goes to show how much you value the work we're doing to fight for reproductive justice and to fight against racism more broadly. So I want to give a little bit of background to this story, introduce the speakers, and then, take the show over, have our speakers take the show over. In 2008, I received this really curious phone call from an aide in Congressman Trent Frank's office. First I've ever heard from this congressional office, and they had exciting news for me about this piece of legislation they were working on, which they were sure NAPAWF was going to be super excited about. And so began our journey at NAPAWF, being one of the chief architects of resistance against the so-called Susan B. Anthony Frederick Douglass Prenatal Non-Discrimination Act. So race and sex-selective abortion bans, which these acts do, criminalize doctors for providing abortions based on the race or sex of the fetus, while copying language of and heroes of social justice and racial justice movements. These bills try to fool us into thinking that these proponents are actually feminists and actually anti-racist champions by so-called preventing the abortions of black babies and Asian female babies. But we know a wolf in sheep's clothing when we see one. You can't give someone rights by taking away their rights. And this is essentially what this law is about. Prendas, as we call them, were developed by the anti-choice movement to chip away at abortion rights for all women. In this case, they do so by exploiting stereotypes of black women and Asian women. And they've developed a so-called solution for a problem that doesn't even exist in the United States. And they show their true racist natures. While legislators claim that Asian Americans are aborting their female fetuses because we have son preference, a recent study by the University of Chicago Law School shows that actually Asian American families are having more female babies by proportion than white families. During the legislative hearing for this law in Arizona, Representative Rick Murphy was asked to present data about sex-selective abortions in Arizona, and he replied, "We know that people from those countries and those cultures are moving here." I'm back. Thank you folks for chatting in about the technical difficulties. We're getting cut off, but I think we're back now, so thank you for bearing with us. Hopefully you heard me go up to the point where I told you about Rick Murphy and what he said about us being those people from those cultures and those countries. And the rest of the quote reads, we know that people from those countries and from those cultures are moving and immigrating in some reasonable number to the United States and to Arizona. And so with that in mind, why in good conscience would we want to wait until the problem does develop and bad things are happening and then react when we could be proactive and try to prevent problems from happening in the first place? The hearing also had a witness proclaim about race-selective abortions that when asked, what is the leading cause of death in the American Black community? The most common answer given by average Americans is heart disease. The correct answer is abortion. Through this rationale, the proponents of this bill show their true colors, and of course this is highly problematic language. It diminishes all the health inequities that our communities face, especially Black women. They patronizingly erase every single reason why we should trust women of color to make their own abortion decisions. And with race-selective abortion bans in particular, they cast all Black women as the perpetuators of their own Black genocide, believe it or not. So since Arizona passed its law, numerous states have followed in its footsteps, mostly with sex-selective abortion bans. In 2012, I was the sole woman and sole woman of color to testify at a federal version of Prenda in a congressional hearing. In 2013 and 2014, sex-selective abortion bans were the second most proposed anti-abortion ban across all the states. And today, sex-selective abortion bans are on the books in 7 states. We've been able to prevent a federal bill from passing thus far, and we're proud to say that in 2015, all 17 jurisdictions that tried to pass Prenda failed, including difficult states like Louisiana and Texas. We, and I'm saying we collectively, because many of you who are on this call were part of this fight with us, we're able to do that by organizing our communities on the ground, reframing the conversation by revealing the true racist nature of what's happening, and by mobilizing new communities of color and allies to the reproductive justice movement. That's how we win. Another way we hope to win is that in 2013, the ACLU filed suit on behalf of NAPAWF and the Maricopa County chapter of the NAACP to overturn Arizona's Susan B. Anthony Frederick Douglass Prenatal Non-Discrimination Act. Dun, dun. I'm going to leave it there because Alexa KOLBI-MOLINAS is going to pick it up after I introduce all the speakers in the order which they will speak. So first up, we do have Alexa KOLBI-MOLINAS. Cue the rocky music. She's been a staff attorney at the Reproductive Freedom Project of ACLU since 2007, and she's our lead counsel on this case, which we're here to talk about today. Admittedly, of course, I'm a little bit biased about our rock star lawyer, but at the moot court hearing last week, it was clear that Alexa is not only extremely sharp and clear in her analysis about what's going on, but she brings the full force of her passion, conviction, and purpose to this work. And for that, I want to thank her personally. After Alexa, we're going to hear from Professor Sarah Burns, who joined the faculty of NYU Law after 10 years of civil rights legal practice. She currently supervises NYU Law's Reproductive Justice Clinic, one of the first such legal clinics in the country. She's trained in social psychology, and Sally is recognized for trial uses of social science evidence. After Sally, you will hear from Eugene Che, who's the senior staff attorney for litigation at AAJC, where he is responsible for the organization's efforts in litigation, including overseeing all of its amicus works. He's previously served as the president of the Asian Pacific American Bar Association of Greater DC area, and also separately served on the executive board of the APAWF Educational Fund. Eugene received his JD from American University, where he was a member of the Law Review. He received the Myers Law Scholarship and served as the Anheuser-Busch Norman Mineta Community Service Fellow. Beer and Norm Mineta, can't go wrong. He also received an MA from Johns Hopkins University and a BA from the University of Pennsylvania. And following Eugene, we'll hear from Priscilla Smith, or Scylla if you're nasty, who is an assistant research scholar in law at Yale Law School, where she directs and is senior fellow in the program for the study of reproductive justice. Prior to joining PSRJ, Smith was an attorney for the Center for Reproductive Rights for 13 years, serving as the U.S. Legal Program Director from 2003 to 2007, and litigated cases nationwide including in front of the Supreme Court for Gonzalez v. Carhart and Ferguson v. City of Charleston. She conducts research and rights on privacy, reproductive rights and justice, and the Information Society. I want to note that Marcella Howell from In Our Own Voice, National Black Women's Reproductive Justice Agenda, was planning on joining us, but is unable to because of laryngitis. We want to thank Black Women's Health Imperative for their amicus brief in this case. So with that, I'm going to turn it right over to Alexa to follow along with the story. How do we get where we are today?
Thank you, Miriam, and thank you for that kind introduction. Can you all hear? I think it's working. So let's go back in time to 2011, that's when this law first passed in Arizona. And at the time, it was the first and only law of its kind to pass. They had introduced a similar law in Georgia the year before, but it had been defeated. So this law passes in 2011, and as litigators, we're faced with a sort of troubling and, for us, unusual situation. First, this was perhaps the first modern law of its kind to ban pre-viability abortions based on the woman's reason. And that was a precedent that was extremely alarming to us and something that we wouldn't want to let stand. But on the other hand, it was basically an abortion ban that probably was not going to prevent any women from having abortions. And that's not usually the situation we're in when we bring these sorts of challenges. And so as a litigator, when you're thinking about the right to abortion in the previous cases we've brought, the law presented a bit of a conundrum. And, while we talk a lot about abortion stigma in our work, and certainly it's been an element in cases we bring, in terms of, are people having trouble hearing me? Okay, sorry. So anyway, we talk about stigma, and we talk about, for example, in cases where we try to explain why it's so hard to find doctors to work at clinics, we talk about abortion stigma. Or in cases about, say, forced ultrasounds and why they're so offensive, we talk about stigma. But stigma had never really been the focus or the real central part of a claim, a legal claim in an abortion case before now. But it is and has been in other areas of law. So, for example, most recently in the gay rights cases and the marriage equality cases that have been at the Supreme Court, the court has talked repeatedly about how the Equal Protection Clause does not permit laws that single out a group of people and impose on them a badge of inferiority. And of course, as you heard Miriam describe the legislative history of this law, that's exactly what it did. And similarly, in religion cases, courts for many years have spoken about how government endorsement of religion or of a specific religion can make those who are not members of that religion feel like social and political outsiders and like second-class citizens. And of course, I can think of no law that would have that effect other more than this Arizona one, right, that cast all Black and all Asian women as, potentially trying to deselect members of their own race or sex. And then, of course, in the race context specifically, courts for many years have recognized that laws that perpetuate racial stereotypes and that target individuals on the basis of race really offend the most basic principles of the Equal Protection Clause. So when we looked at it from that angle, the constitutional problem with this law was very clear. We had every hearing that the Arizona legislature held on this law on video. And you only have to watch those videos to see much more than what Miriam just shared with us in the introduction. Just repeated use of stereotypes, of outward racist intent, of singling out Black and Asian women, vilifying their abortion decisions, and deliberately setting up a system in Arizona that would scrutinize the reasons they have abortions specifically. And as a lawyer, as a person, the legislative history is incredibly offensive. As a lawyer, it was a total gift, right? Because you don't usually get a legislative history just with all your evidence of racist intent right there for you. But that's what we had with this case. So we got this lawsuit in 2013, not as a right to abortion case, but as your quintessential equal protection case. A right to be free from an intentionally discriminatory law that perpetuates racial stereotypes. Now, not surprisingly, after we filed the case, the state of Arizona moved to dismiss it. Though there was something really notable, I think, in how they moved to dismiss it. They didn't deny what the legislators said or try to justify the law in any way. They simply cited an old Supreme Court case that says, stigma, in and of itself, is not sufficient legal injury to give you standing to challenge a law, or at least that's how they read the case. So their view was basically, unless we could show that a woman couldn't actually get an abortion, we didn't have a claim. But of course that's a catch-22, right? Because it would mean the government could pass a law deliberately targeted and racially profiling women of certain groups. But because they were being profiled for a so-called crime that none of them were committing, they had no legal recourse. Unfortunately, the district court agreed with the state's argument and dismissed the case. So then we filed our appeal, and our appeal and this question of stigma as legal injury is what's going to be argued at the Ninth Circuit Court of Appeals on Wednesday.
Great. Thank you, Alexa.
You're welcome.
I think to continue on with the story and to share some of the arguments used in the amicus brief, we'll take it to Sally next. Can't hear you, Sally.
Can you hear me now?
Very good.
Okay. So my job in this case was to represent social psychologists who came as amici, friends of court, to present their social science research with respect to the harm of stigma. And in this case, the purpose was to, in a sense, answer the question of standing and to confirm in scientific terms that there is concrete harm from stigma of laws like Prenda. So the brief, and I have to say we crammed quite a lot because there's quite a lot of research to refer. The brief, which could only be 15 pages, is a compendium of hundreds of social science research results. And I would draw your attention, I believe it's available online at National Asian Pacific American Women's Forum, but you can also get it from me if you need it. So we made two general arguments. The first was that the use of stereotypes stigmatize and injures socially marginalized groups and their members by denigrating and isolating them. That's just the common sense that we all know about stereotypes denigrating the groups that they stereotype. And we did make the point of citing the specific research that says it doesn't need to be stereotypes which are overtly hostile, and a good bit of research now on just that point. We know that scenarios like Arizona's legislature passing the law that they passed, the Prenda law they passed, strengthen stereotypes of the likelihood that dominant group members were denigrating subordinated groups. In this case, African American and Asian Pacific Islander women. But the largest part and the most, I think, novel from the standpoint of the court and for most of us is the research that has really developed quite extensively in the last 20 years of relating stereotyping and stigma to health, cognitive functioning, and socioeconomic harms. In essence, the research that we were citing, and ultimately it was 42 social scientists, social psychologists in the United States and in Canada who joined us, and this is actually their life's work, if you will, and they were quite eager to make sure that this research got before the court. The notion that stigma is a threat to identity is well established, and it works in two ways. First is that the fear that the individual might be evaluated through the lens of stigma by majority group others, but also that one might, as a member of a stereotype group, confirm the stereotypes. And both of those dynamics work very powerfully. Here, Asian Pacific Islander women and African American women struggle with prenda because they are not seen as good women or as good mothers or worthy representatives of their group. So as to health harms, there are two kinds that the social scientists have documented, and I'm happy, by the way, to talk about the extensive and well-developed methodological background to the studies that we cited. The first, and I think the most powerful, is the physiological harm. The evidence is very good now that stress and stigma causes stress, and that stress has results like increased cortisol, increased blood pressure, and other cardiovascular outcomes. The long-term effects of stress like this include chronic diseases like diabetes and hypertension. There is, therefore, a link between stigma and mortality, and there's a beautiful line of research by Mark Hatzenbuehler at the Columbia School of Public Health relating public policy stigmatic harms to it's a correlational study, but to mortality. The research also shows that group stigmatization in particular impacts both immune and endocrine processing. And this is important. That there's research now that suggests that it is even more harmful. I mean, we all understand there are situations in which people suffer individual discriminatory harm, but there's also very powerful research now that suggests that the very fact of being a member of a group that's stigmatized is even more harmful than being the target of an individualized discriminatory act. There's also, of course, quite obviously, psychological stress that relates to depression, anxiety, and other similar symptoms of psychological distress. One of the issues in this case is that where an attribute can be hidden, and in this case, the attribute an issue would be whether one chooses to have an abortion or has had an abortion, there's increased harm from the fact that one becomes more isolated and is deprived of mutual support. That isolation is also a cause of a loss of other resources, which also is linked to negative health harms. The other aspect of stigma and stigmatic stress is that it leads to maladaptive coping, or can lead in some individuals, which includes behaviors such as substance abuse, unhealthy eating, and excessive worrying. We also know that stigmatic harm and the stress of it affects performance, individuals in their cognition and their performance situations, and particularly stress adds a cognitive load, which is excessive vigilance and negative emotion, and this particularly impacts and causes a decrease in working memory. These kinds of effects, these kinds of effects then translate, unsurprisingly, to impacts in life, like career, income, and housing opportunities. And I will leave it at that, and I'm happy to talk further in question and answer.
Thank you so much. Eugene, you're up next.
My name is Eugene Che. I am a senior staff attorney with Advancing Justice / AAJC here in the district. Our name is kind of complicated, so please excuse that. But we filed a amicus brief in this case. And for those who are unaware, amicus just means friend of the court. Advancing Justice, AAJC, is not connected directly to this litigation, and therefore we come in as amicus, as a friend of the court. And our purpose is to file a brief with the court that tells the court how this is going to impact the communities that we exist to serve, and how the court's decision may impact hundreds, thousands, millions of other people that are unaffiliated with the case, but are in communities that we care about. So what we did is we filed an amicus brief with the court in this case, outlining the rather lengthy history of legislation that was in one way or another outright discriminatory against Asian Americans. And there, some of the legislation, some of the government actions were facially race neutral, but in effect, they were discriminatory by their motivations against Asian Americans. And we wanted to point that out for the court. If you look at the legislative history of this bill, HB 244, it's pretty apparent that the comments on the legislation were motivated by stereotypes of Asian Americans as perpetual foreigners, or of Asian culture as a cultural threat. And these stereotypes continue to result in discriminatory laws that stigmatize the Asian American community. It's been that way for years, and it's actually, there's quite a lengthy history of this. The United States has historically enacted legislation and taken government action that history in retrospect has not been kind to. With the benefit of hindsight, it's apparent that even when some of these acts, some of this legislation, some of these government acts are race neutral, the laws themselves are discriminatory, and specifically against Asian Americans. Specifically, I can mention the Page Act of 1875, which restricted immigration for lewd and immoral purposes. Facially race neutral, but it was found to target Asian prostitutes. The Chinese Exclusion Act of 1882 prohibited immigration of Chinese laborers. That was rather explicit. The Immigration Act of 1917 established an Asiatic barred zone. That also was rather explicit. The Tidings-McDuffie Act of 1934 imposed quotas of 50 Filipino immigrants. And if you look at some of the language of these types of legislation, you're going to see language like this, which I'm going to draw out from the Chinese Exclusion Act. Or actually, I'm drawing out from a Supreme Court case that discusses the Chinese Exclusion Act. The presence within our territory of a large number of Chinese laborers of a distinct race and religion, tenaciously adhering to the customs and usages of their own country, and incapable of assimilating with our people, might endanger good order and be injurious to the public interest. So you can see that we as a nation have a history of enacting legislation that is of questionable motivation and certainly has negative effects against a particular population, in this case, Asian Americans. And it's not just legislation that's enacted on a national level. We can also look at some local legislation, such as California's alien land laws, that prohibited aliens ineligible for citizenship from owning agricultural land or possessing long-term leases. The laws made no mention of race or color or nationality, but the Supreme Court recognized that there was a history. the legislation was a reaction to the influx of Japanese immigrants and the fear that they created as outsiders to American culture. And there was a history of charging Japanese Americans with espionage, unassimilativeness, clannishness, and corruption of young children. And of course, the most infamous example of government action that was spurred into, that came about as a result of a stereotype of Asian Americans as a perpetual foreigner or a cultural threat. The most famous example is Executive Order 9066, the internment of Japanese Americans during World War II that resulted in the internment of 120,000 Japanese Americans. Internment wasn't sought on the basis of actual data, but to quote some language from the Supreme Court, it was based upon questionable racial and sociological grounds that individuals of Japanese ancestry are a large, unassimilated, tight-knit racial group bound to an enemy by strong ties of race, culture, custom, and religion. Basically, that Japanese Americans were always going to be outsiders, and they were perceived as such. The legacy of all of these laws, going back over 100 years, is that, particularly in the case of Japanese American internment, these laws are repugnant, they're contrary to the Constitution, they're not who we are as a society, and they have to be repudiated. And it was the purpose of Advancing Justice, AAJC's brief to the court, to point this out to the Ninth Circuit and make it known that we have a history of this type of legislation. It's been a mistake in the past when we enacted it, and it's a mistake now, and the Ninth Circuit needs to recognize that. HB 244.3, the sole rationale rests on the unsupported perception that a special law is required to regulate the conduct of Asian American women who are assumed to engage in the practice of sex-selective abortion. And I just want to take this opportunity to quote some legislators who were instrumental in pushing this legislation through, and to really highlight how their motivations involving surrounding the legislation was really based on stereotypes of Asian Americans, of Chinese Americans, of Indian Americans, and I think their quotes will
Just
show
30
that.
more seconds, Eugene.
Oh my God, okay. I'll just quote one.
I know there's a lot to choose from
There
in that
it
legislative.
is. All right, let me skip over that. Okay. HB 244.3 was not enacted to respond to any documented issue, but respond to a perceived threat that Asian American women were conducting these sex-selective abortions. It's a lot like how Japanese Americans were incarcerated in World War II, not on any data, not on the basis of any data, but because of perceived threat that they were creating to the state. Okay, I'm just going to leave it there. Thank you very much.
Thank you, Eugene. Okay, Scylla, you're our cleanup hitter.
Can you guys hear me now?
Yes.
Oh, that's so
Hear you,
exciting.
and we can see you. It's so exciting.
Oh, yay. That's so exciting because my audio has had a red line through it the whole time until now. So exciting. Okay. So our job here was really to take the next step after the two amicus briefs you've talked about and support the legal standing arguments that were being made in the case. And you've heard this excellent arguments made in the other briefs about the reality of harm caused by stigma and the history of the racial discriminatory practices in other contexts. And what we were here to do was really simply to provide a kind of academic veneer, I think, and a little bit of a theoretical analysis to some of the arguments that the parties were making about standing in this case. Because the hard thing about this case is that you're going into court saying, we're challenging a law that causes racial stigma, based on racial stereotyping. It promotes racial stereotyping, and it causes us injury for this reason. But it's not a law that prevents us from getting abortions, because in fact, it's a wrong-headed law and we don't obtain abortions for the reasons that are banned under the Act. So the tough thing about standing doctrine in particular is that it requires you have a direct injury, right? So you have three allegations in the case. There's rationales based for the law is based on racist stereotypes. The purpose is to promote stereotypes. And then we decided we would use this idea that the law actually subjects the women's decisions to obtain the abortions to increased scrutiny because of the law, as something that really gives you a strong hook to establish that the law causes direct injury, that there's a connection, right? So the three requirements in standing law are that there's a personal injury traceable to the defendant's conduct. That's a direct, it's caused by the conduct is the second requirement, and the third requirement is that it's redressable. Now, it's interesting to note, this is not true in all countries and in all courts. In some courts, you don't have to have this kind of direct injury. You don't have a standing requirement. You can go in and challenge legislative conduct for being illegal and unlawful under some regime without having a direct connection. But in the US, we have this very strong and sort of, I think of it as a very strict and overly strict cases and controversies requirement. But it's something that is really fundamental in our jurisprudence and is meant to preserve the separation of powers, etc. And courts are very attached to standing doctrine. The Supreme Court is very attached to standing doctrine. And most people in general just take it for granted as a very important thing in the law. So what we said is that the purpose of standing doctrine was actually preserved in this case. We went through some of the background about that. And we pointed out that under the Supreme Court cases that the trial court relied on, actually, there is standing in this case. So the trial court had relied on a case called Allen versus Wright to say that, and had interpreted that case as requiring a denial of a material benefit to prove the direct injury being caused. And we said, no, that's an incorrect interpretation of Allen, especially in the Ninth Circuit, where really what you have to do is show that the law causes you the stigmatic injury, but you don't have to be denied some other material benefit along with it. So Allen versus Wright was a case where they said you couldn't have a nationwide class to challenge a policy in one school district that was causing stigmatic injury to people in the school district. You couldn't direct your or connect your stigmatic injury on a nationwide basis with that one school district. But if you were in the school district, you could. So we said, here there are people who have alleged, in fact, that they're being treated differently when they seek abortions because the decision that they're making about getting an abortion is being scrutinized with this whole veneer of racism and stereotyping going on. So women who are African American and women who are Asian Pacific Islanders are being scrutinized by the abortion providers, who are forced to write down reasons that women are getting abortions. And they're being scrutinized more than white people are, certainly, and even people of other racial and ethnic backgrounds because of the stereotyping supported by this law. So we really tried to do a very doctrinal piece and tie it to these cases very clearly, and to tie it to some really very good precedent in the Ninth Circuit, Catholic League, and some other cases that talked about offensive symbols and showed that there was standing to challenge offensive symbols that cause stigmatic injury, even if you weren't changing your conduct in any way or you weren't denied any material benefit. You just had standing because you had a connection, you had a direct connection to that, to those symbols, and that was enough. We also made an argument then about the Establishment Clause cases and the Equal Protection cases to point out that the standing requirements in Establishment Clause cases should also apply to the Equal Protection Clause case here, because the concern is the same. The concern is the stigmatic injury, the harm caused in those cases, and what we're trying to do in equal protection doctrine is to prevent stereotyping and the harm caused by stereotyping, as well as direct denial of material benefits. So that was basically what we did, and it's a tough argument in some ways, and I think Alexa is going to get a little beaten up in the Ninth Circuit, but she's tough as nails and she's got a great argument, and she's, you know, the briefs are excellent in this case. So I think that I'm very optimistic, actually, although I think it's a very tough case. In other circuits, I think in other circuits it would be tougher, although there's a great case in the Fourth Circuit as well that should help. So, and I think it just makes sense in terms of enforcement of equal protection and equality standards. And if you get a decent panel, you know, it's going to be all good, all clear sailing for Alexa. Thanks.
Thank you. Alexa's going to rock it no matter what panel, but I think we are going to be okay. Thank you all for those really thoughtful and clear remarks in what is a very tricky and kind of difficult legal issue that we're facing. I want to invite folks who are on this webinar to chat in their questions now. If you have a question for one or any or all of the speakers, please go ahead and write that in so that I can read them, consolidate them, and share them. I want to, so if you see on, there should be a chat box that you can write a message, and that's how you can get in. So we're getting one question that's been submitted is, what is the consequence of the law on the ground? Would it virtually prevent Black women and Asian American women from obtaining abortions across the board? Alexa, do you want to handle that one?
Sure. So, you know, as far as we know, the consequence on the ground has been that this law has not prevented Black and Asian women from being able to obtain abortions. The way the law works in practice is that it requires every physician who performs an abortion in Arizona to complete an affidavit for every patient that he or she sees. And that affidavit has to state that the physician has no knowledge that the reason the woman is seeking the abortion has to do with the race or sex of the fetus. And as far as we have heard, you know, nobody has been turned away and been unable to obtain an abortion because of that requirement, which is, you know, pretty much what we expected when we filed the lawsuit, and it's why we didn't bring it as a ban on abortion sort of lawsuit, because it wasn't going to operate that way. It was going to operate in the way that the legislators who sponsored it and supported it wanted to, which is to sort of individually target and stigmatize women who have abortions and make abortion just seem ugly. And that's, you know, what their goal was, and that's the basis on which we're suing it.
I will add on to that, you know, it may not prevent women on the ground from having abortions, but we do believe that asking these questions mean different things in different communities. We have members that we're suing Arizona who come from families who were interned, who are Japanese American, and just having the the experience of being questioned by your doctor about why you're having an abortion, I think feels different to some communities than others. As Sally talked about, it creates stress, it creates self-doubt, it creates a whole atmosphere of pain to have to bring that up. And I think it does lead to racial profiling in the office or doctor's office, or could. Essentially, that's what the attorneys during the congressional hearing said. That when asked, "How are you going to enforce this?" the other side attorney said, "Well, if an Asian woman comes in and she already has 2 girls and she wants an abortion, you better ask her why she's having an abortion and whether it's because of the sex of the fetus." And I think those accusatory tones hurt in particular. So if there are other questions, please keep chatting them in. If not, I want to ask a kind of a snowball one, right? Like, so recently in the news, there's been a huge amount of Islamophobia. And you may have seen on Facebook that there's this case about a gun shop in, I think, Florida, right? Posting a sign that says, "This is a Muslim-free zone." And now they're selling Muslim-free zone stickers. And the Council on Arab-American Relations has sued, but they too are facing a standing issue because a Muslim hadn't gone to that store to try to buy a gun. How is it that, like, people of color and women of color can see so clearly the harms of racism, and yet our court system not? Philosophical question. Scylla, you're looking philosophical. What can we do about it?
Okay, here, I clicked my audio. What can we do about it? Well, first of all, those cases are a little different in that you're not challenging the government directly, right? You're challenging private actors. So these are like these public accommodations cases. So you bring them under a public accommodations law, and they should win under public accommodations law because there's a sign that says Muslims free zone, so Muslims are not supposed to go in. It's like you can't sit at this lunch counter. So those in some ways are more direct in a legal matter. That's not philosophically. To answer your philosophical question, I think there's a lot of things going on. There are just plain, straightforward racism. Why can we see it and judges can't? Because they are never told they can't. They're not racially stereotyped, at least not in a way that they find harmful. I might racially stereotype them, but it's not doing them any harm, really, for me to make fun of them or for them to be made fun of on Saturday Night Live or something for being old white guys. So I think they don't have personal experience of this kind of negative impact of stereotyping. I think pure and simple. That's why those people can't see it, and we can. We've been subjected to it. What does that mean for the law? It means that's why it makes sense to have more women judges. That's why it makes sense for us to have more people of color who are judges. They're more sensitive to the real impacts of these kinds of actions, as and they become educated more and more. They're sensitive to being educated, even if they aren't already educated. So looks like Sally's got something to say too, and Eugene.
Thank you. And then we have a good follow-up question after that. So, Sally, if you want to weigh in on this question?
No, I was reading the moderator notes. Thank you.
Yeah, a couple of questions are coming in, and I think the last 2 that I just posted are a little bit connected. A question about race-selective abortion bans and whether they're spreading, and what other states have been doing, and how this decision on this case would mean, what impact that would mean. Alexa, do you want to weigh in on that? Can't hear you. for some reason. Can you hear you now? No.
Yeah.
Okay. Okay.
Now you can hear me.
Yes.
So the interesting about the race selective abortion ban specifically, this is, the Arizona law is the only law that was enacted that is both a race and sex selection abortion ban. And I think, Miriam, you would know better, but I think more and more now we are seeing laws that are just sex selection bans being introduced and being enacted. I think they still have race, or sometimes include race as an element in the federal version of the bill when it gets proposed. Sometimes, though sometimes I think they've proposed it without it. So I actually haven't seen as much of a trend with the race-selective abortion bans. It's sort of one of the other reasons why Arizona's law is so unique, and perhaps even they realized that they went a little too far with that one. So then in terms of, so I guess that sort of explains how they are different. The ones that are being introduced across this country are different than HB 2443, Arizona's law. But in many other respects, they're completely similar. And the legislative history, particularly on the anti-Asian stereotypes and sentiment, is the same in many of them. I think the decision in this case so in the immediate effect is that it only would affect, this law and potentially other laws within the Ninth Circuit, though I don't think there are any like this within the Ninth Circuit. But, I think our hope would be that it would put other legislators and other states on notice that, this is, we're not kidding when we tell you this is unconstitutional and you shouldn't do it. So I think that would be the hope that of a win in this case.
Fantastic, thank you. And I think regardless of this case, even though I truly believe we will win and prevail, there are a number of actions that we can all do to help support this case and this issue moving forward. So in the final moments, I want to just share 3 suggestions and follow-ups as we start to close out today. One, if you are interested about reading the fantastic amicus briefs, amici briefs, or there's another way to pronounce it, it's like tomatoes and tomatoes. You can find them online on NAPAWF.org. There's a rotating banner that we have for this issue. Click on there and it'll take you to a page where you can download all the terrific briefs that were filed in support of us. It's interesting, the one brief that was filed by the opposition basically just says, it's not a stereotype. They're really doing it. They just kind of stick to their guns. They're really amazing that way. So go to napawf.org to find the briefs. On Wednesday, if you're in the San Francisco Bay Area and want to watch Alexa and pump her up and cheer her on, our star attorney from the ACLU, drop me a line and I'll send you information about how to get into that courthouse to do that and what we might be organizing then. And then for all of us who are not lucky enough to be in the San Francisco Bay Area, on December 9th, Wednesday, we invite you to follow along with us at #RacismHurts all day long. We'll have folks hopefully live tweeting from the hearing if we are allowed to live tweet from the hearing. And especially from 2 to 3 p.m., we're hosting a Twitter storm at @RacismHurts #. So please plan some tweets or please participate and add some tweets from 2 to 3 Eastern time about your lived experience about how racism and racist stigma hurts in our community, so we can send a message to the courthouse and beyond that these aren't just legal issues that we're arguing about. Women of color and allies know that racism does cause harm and it does hurt, and we must act collectively to fix that. So those are our 3 calls of actions. And with that, I want to thank our panelists so very much for taking this time to talk with us today and for all the incredible work that you do each and every day. Yay, very good.